it's not just being guilty of murder. It's also all these financial crimes that he's being charged with. I think he's being charged with like, I don't know, for like 90 financial crimes. Like this is wild. He was scamming his clients. He was scamming everyone. And then he had this whole roadside shooting where he tried to fake assassinate himself, hiring his cousin Eddie, who was potentially also his drug dealer. Like this whole story was a whole mess. But before Alex Murdaugh went to his murder trial, he went to a bond hearing. I think it was a bond reduction hearing. And it seemed like, you know, he wanted to have everything cleaned up. So he put in like a judgment of, what's it called? Something of confession, where he basically confessed to the financial crimes. And, you know, he was telling the Satterfields like, hey, you know, like I scammed you guys. I'm sorry, blah, 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 blah. And now that the trial's over, he's like, you know what? I want to have that judgment of confession. Fuck, I don't know if that's what it's called. I want to have the confession thing thrown out. I want to have it thrown out. And, you know, he said that like, I want to have it thrown out. And also because, you know, the dogs didn't really trip the housekeeper. It was actually something that I made up. So his housekeeper, Gloria Satterfield, has been working with him and his family for a couple of years. And I think essentially even helped raise one of his sons, Paul, who he murdered. And well, Gloria Satterfield's been on the property for a long time, helping them out and everything like that. And then one day she has this horrible fall and Maggie and Paul are there calling 911 and Gloria Satterfield ends up dying a couple weeks later. But Alex Murdaugh swept in and was like, you know what? I actually came to the property after she fell and she whispered to me only, that the dogs tripped her. Even though when Gloria Satterfield went to the hospital, she just said that she doesn't really remember, but she tripped. She never mentioned any dogs or anything like that. But Alex Murdaugh was very, 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 you know, he was trying to convince everyone that it was the dogs that did it because he wanted to collect a life insurance policy. There's a term that I'm looking for and I can't pull it up out of my head right now. It's Monday today, okay? Accidental injury, something like that. But essentially in South Carolina, there's a strict liability if your pet harms another person. And so he essentially wanted to say that, hey, my pet is liable for, you know, the death of Miss Satterfield. And so I want my insurance policy to pay out to the family. And so that's what he tried to do. And there was two policies two insurance companies that was going after for the money. And so he was able to get the money from one of them, I believe. He was fighting the other one to get the money on that one. But essentially, the Satterfield family didn't see a dime. They didn't get anything. What had happened was Alex Murdaugh and his friend, I think Corey Fleming, and maybe some other people that were involved, it seemed like they transferred the money into Alex Murdaugh's account, and that's it. The family didn't get any money at all. I don't know. They did a lot of shady stuff where, you know, they kept the money, and yeah. So what's going on right now is that there's this whole court battle between the Satterfield family, Alex Murdaugh. Alex Murdaugh is saying like, hey, you know, the insurance company is now coming after me. But, you know, technically, you know, the insurance company shouldn't have paid out the money anyways because I made up the lie. So what you also really need to do is go after the Satterfields as well. But the Satterfields are like, well, we didn't really get any money from you. You're the one who took all the money. And it's just like, it's just a whole mess. Yeah, he ended up, Murdaugh ended up pocketing like almost 4 million, I think. It was like 3 million something. But sorry, this is all just from memory right now. I have the document here. I don't know why I'm talking. I'm just going to go over the document. All right. Memorandum of law in opposition to motion for relief under Rule 60B and the motion for sanctions. Memorandum. At its heart, the defendant's motion for relief. Oh, I should wear my glasses. From judgment pursuant to South Carolina Civil Procedure. Why is it dirty? Rule 60B, the motion asks one simple question. May I have a mulligan? More aptly described through their motion, Team Murdaugh, which also includes Murdaugh and his counsel, have stumbled late on their judicial first tee with a small bucket of balls with an apparent attempt to fire shots until they finally hit the fairway. I don't play golf, and there's some golf references in here. I'm assuming maybe the judge is really into golf, and that's why they decided to throw it in there. Maybe it'll be favorable towards the judge. I don't know. Mulligan golf. What is it? So the term mulligan in golf, a mulligan is simply a second chance shot when a golfer has hit a poor tee shot that they would rather forget. Okay. I guess it's a do-over then. It's a do-over and a second chance at shot. Okay. That's why they're saying Murdaugh and the Loras, they want a mulligan. No, Harpoolian didn't write this. This is This is the memorandum asking for the sanctions of Murdaugh and his lawyers. This was from Team Satterfield with Richter and Bland as their lawyers. Obviously, Murdaugh is not a golfer. Neither are his lawyers. There are no mulligans. Like a spoiled child, the motion is overindulged and undisciplined. Murdaugh's argument seems to be, because I commit fraud on the court in the underlying cases, I'm entitled to be relieved of my confession judgment now. Oh, that's what I was looking for. Confession judgment. Sorry. Confession judgment. So I had it right the first time when I was saying it. By this memorandum, the plaintiffs will expose the many whiffs, slices, tops, blocks, chunks, hooks, and duffs. That has to be all golf references, right? That need so needlessly wasted this court's time and have unnecessarily caused a further victimization of the Satterfield family, thus entitling the plaintiffs to sanction against both Murdaugh and his legal counsel in order to punish their conduct and deter such similar abuses of the plaintiffs in the legal system going forward. Whiff. One cannot point to their own fraud as a basis for relief under Rule 60. While Murdaugh seeks equity from the court, he has not discharged equity. Therefore, he is foreclosed from the relief he desires. To put the matter bluntly, whose hands could be less clean than Murdaugh's? So I'm just skipping all the citings. Even according to his own motion, Murdaugh cites as a basis for seeking equitable relief under Rule 60 that he has lied and misled his insurance in the court. Mr. Murdaugh lied about the dogs, undeniably obvious from the record now available, made even more apparent by Mr. Murdaugh's lengthy testimony at his recent criminal trial, wherein he admitted an unfortunate years-long pattern of drug-induced theft and dishonesty. I don't know if I believe that part. To paraphrase, Murdaugh urges the court he should be believed now because when he says that he lied earlier about how Satterfield was injured, through a twisted application of Murdaugh's logic, the point Murdaugh seems to make is that if he lied about the dogs, then the insurance company should have never paid him any money that he stole, as a result of which he should be relieved of the confession of judgment. He gave the Satterfield boys some years later because there should have never been a Gloria Satterfield wrongful death claim and recovery in the first place. And of course, later in this document, it says that the reason why he did the confession of judgment is because he wanted to essentially, I don't know, probably when he went to his bond reduction hearing, he probably wanted the judge to reduce his bond, but the judge didn't. And he was like, well, I cleared everything with the Satterfield boys. I'm on good terms now. We're good. I'm putting in my confession of judgment. Please, judge, reduce my bond. And the judge was like, nope. It seems like it didn't help him. And so now he's like, well, if it didn't help me, I might just take it back. Take it back. Take it back, please. Okay. He gave the Satterfield boys Murdaugh gets to keep the stolen money of something to that effect. And this Murdaugh suggests should entitle him to seek equitable relief from the court under Rule 60. The motion suggests that it raises novel issues. It does not. It raises nonsensical issues. If the motion is novel, it is only novel in the sense that it is the byproduct of a disgrace, a former attorney with the time, depravity of mind, and sheer balderdash. What is balderdash? Balderdash. Senseless talk or writing. Nonsense. Balderdash.
Balderdash.
Balderdash? Balderdash. Okay. New word, guys. Balderdash. Where are my SAT people at? Sheer balderdash to have conducted it. Moreover, the motion is nothing more than a continuation of the mockery that Murdaugh has made of his prior profession and the administration of justice itself. I wonder, is Judge Newman, is he still overseeing the financial stuff? Dude, he must be so sick of Murdaugh. Judge Newman, man. The fact that Murdaugh's latest abuse of the system and continued victimization. I've heard of balderdash before, but I don't know if I really knew the definition for it. It sounds like a game. Isn't there a game called like Baldur's Gate? The fact that Murdaugh's latest abuse of the system and continued victimization of his victims is facilitated by his current counsel, subjects all of them, get them all, to sanction as addressed below. But before digressing, the motion is fatally defective and factually flawed in too many additional particulars to ignore. As to this point, however, the inescapable conclusion is that the Murdaugh's admitted fraud does not entitle him to equitable relief. Number 2, slice. Murdaugh has to continue to play fast and loose with the courts, which precludes him from the relief he now seeks. The doctrine of judicial estoppel, I'll look that up really quick. I do know what estoppel means because I remember I looked up for Ben Chu. The principle which precludes a person from asserting something contrary to what is implied by a previous action or statement of that person or by a previous pertinent judicial determination. Estoppel is an equitable doctrine, a bar that prevents one from asserting a claim or right that contradicts what one has said or done before. All right, estoppel. Because I remember Bentley said that a lot too. Wait, I think it literally defines it right here. Oh, my bad. Stating goal of judicial estoppel is to prevent a party from playing fast and loose with the courts and to protect the essential integrity. As explicitly embraced by our Supreme Court, judicial estoppel precludes a party from adopting a position in conflict with one earlier taken in the same or related litigation. When a party formally asserted a certain version of the facts in litigation, he cannot later change those facts when initial version no longer suits him. Ooh, I like how it says that. When it no longer suits him. The application of judicial estoppel is an equitable concept depending on the facts and circumstances of each individual case. Let's go back to Murdaugh. The point is twisted even by Murdaugh standards, but in this Rule 60 motion, Murdaugh takes an inconsistent position, with positions taken in other litigations by lying to this court about having lied about the dogs. What the motion advances is part as the basis for relief. You know what's interesting about this is that we learn that it seems like the insurance company didn't even believe Alex Murdaugh that Gloria Satterfield was tripped by the dogs. But the reason why I think they ended up paying was because they were scared of Alex Murdaugh and his team of lawyers going after them and suing them. So they probably just wanted to settle just to fucking move on. What the motion advances in part of the basis for relief is that Mr. Murdaugh lied about his own liability for Ms. Satterfield's death to fraudulently obtain insurance proceeds to perpetuate his severe opioid drug habit. But did he really? Yes, in an interview with an adjuster, it is true that Murdaugh explained that Gloria's fall was caused by his dogs, a fact that appears supported by both Paul and Maggie at the time. But Murdaugh never advanced his position to the court that approved Nautilus' settlement, and he actually negotiated for a release that stipulated he had no liability. In the petition for approval settlement in the matter of Gloria Satterfield, on or about February 2nd, Gloria Satterfield received injuries after falling down in front of the stairs of Colleton County, South Carolina residence owned by Richard Alexander Murdaugh and Margaret Murdaugh. Decedent Gloria Satterfield subsequently died. Omitted from the petition was any reference to the dogs. The petition was subsequently approved by the order approving settlement, a copy which is attached. The order found that it appears on February, Gloria Satterfield, Importantly, the order further found it is denied by the parties to be released that the injuries and subsequent deaths suffered by the decedent was a result of any negligence or reckless conduct of any released party. Like the petition, the order contained no finding that the dogs played any role in Gloria's fall or subsequent deaths. The order did, however, authorize Chad Westendorf, a personal representative of the estate of Gloria Satterfield, to execute such documents as would full effect of release in favor of Richard Alex Murdaugh. So I believe Chad Westendorf is a friend of Murdaugh. Specifically, the order authorized Mr. Westendorf to execute the release attached hereto as Exhibit C without referencing the dogs at all. The release recited that Gloria Satterfield received injuries on or about February 2nd, 2018, after falling down in front of the stairs of Colleton County, South Carolina residence owned by Richard Alexander Murdaugh and Margaret Murdaugh, and that Gloria subsequently died. Importantly, the release stipulated that Murdaugh had no liability whatsoever in Gloria's death. So assuming it matters, and it does not, why did Nautilus pay the Gloria Satterfield claim? The reasons are manifold as described in the second comprehensive report, which evaluated the Satterfield claim and was prepared by Nautilus for an outside legal counsel. A copy which is attached here to is Exhibit D. The reasons Nautilus settled the claim included no particular order. A. Based on an interview with Paul reported that in the presence of his father, he heard Alex ask Gloria what happened, and that Gloria said something about the dogs. Paul also reported having woken up by the dogs and coming outside to find Gloria at the bottom of the stairs. Wait, so this is saying that they interviewed Paul? Paul reported that in the presence of his father, he heard... Does that mean that Paul said that he heard Gloria tell Alex that the dogs happened or something like that? Hi, Rain. How are you doing today? Sorry, that the dogs were there when it happened? Paul also reported having awoken by dogs and coming outside to find Gloria at the bottom of the steps. Based on an interview with Maggie, Maggie described that all 4 dogs were loose on the property, that she was awoken by the dogs barking, that she went outside to find Gloria at the foot of the steps, and the dogs were walking near Satterfield. Maggie added the dog named Bourbon was just horrible, was attention-seeking, and was known to get under people's feet. What? Horrible? When asked what she thought happened, Maggie stated her belief was that the dogs got in Gloria's way as she came up the steps. Alex Murdaugh was not present at the time of the fall, but arrived later. Alex claims that Gloria told him the dogs had tripped her, a fact that appears corroborated by Paul. I thought Alex never showed up at his property. I thought Alex only showed up when she was already at the hospital. The venue of lawsuit filed was a key issue, as the suit would likely be in Colleton or Hampton counties, which are located in plaintiff-friendly circuit. The 14th Court has 2 resident judges, Judge Perry Buckner and Judge Carmen Mullen. These judges know Murdaugh and Mr. Fleming well. The real reason Nautilus settled the claim is that it made an economic decision that the risk of litigating with Murdaugh on his home turf was too great. So it seems like they just paid him out not because they believe his story, it was because they're like, you know what, it's not worth dealing with it. Let's just give him the money, whatever. As insurance companies do on a daily basis, Nautilus had a right and free agency to deny the claim and tell the claimants what they tell every day: prove it. Nautilus shows otherwise. In doing so, they had conducted their own independent investigation in the circumstance surrounding Gloria's fall. They were assisted by outside counsel, and they negotiated for a resolution that included the stipulation that Murdaugh had done nothing wrong. Bourbon and Bubba, both being framed. As the orders approving the 2 settlements comprising $4.3 million has never been challenged, it is the law of the case that Murdaugh had no liability in the fall that caused the injuries and the death of Gloria Satterfield. The matter was resolved for business and other insurance companies' internal reasons unrelated to any recently self-admitted fraud. Again, Murdaugh has led the court that the reason the claim was paid was the result of having misled the prior court in approving the Nautilus settlement. One can only imagine that when someone had manufactured so many mistruths, it becomes difficult to keep it all straight. But the reality is neither the petitions, the order, nor the release mentioned dogs as it relates to Gloria's fall. So I think back in a couple weeks ago, Murdaugh was like, you know what? Gloria's fall was not caused by the dogs. But now we have this document here that says, like, you know what? Like, the money that Murdaugh was given anyways, it's not because they gave it to him because they believe his story. They gave it because they were afraid that he was going to, it's not worth going to court with him, you know? This is playing fast and loose, and it is out of bounds. Hi! Hello, guys. What's going on? But this is not only the matter in which Murdaugh has and continues to play fast and loose with the courts. As it relates to the confession itself, that Murdaugh describes in the present motion as a legal nullity, he has at least twice not acknowledged the confession in other courts as being valid. Related to Murdaugh's criminal indictments for having stolen millions of dollars from the Satterfield family, Murdaugh had a bond reduction hearing before the Honorable Allison Lee on January 18, 2022. This is the part that I was talking about earlier about the confession of judgment and why they think Alex Murdaugh decided to do this confession of judgment. The negotiation of the material terms of the confession of judgment took place advance of the bond reduction hearing. It was important to Murdaugh to execute the confession prior to the bond reduction hearing for 2 important reasons. First, he wanted to be able to report to the court that he had settled his disputes with the Satterfields. Second, he wanted to quell further opposition from Bland and Richter to his request for a lower bond. During the bond reduction hearing, Murdaugh and his legal team reported to the court that they had resolved their disputes with the Satterfield family and that Murdaugh would be signing the confession. Much to Murdaugh's dissatisfaction, Judge Lee did not lower his bond. Good. Clearly, when it served Murdaugh's purposes to advance the validity of the confession to the court, he did so. To be certain, the court accepted the representation that Murdaugh had made matters right with Satterfield as it went without challenge. One may suppose that Murdaugh is now dissatisfied that he didn't get the value that he sought at the time by telling the court that he would sign the confession. But his perceived lack of value is no basis for a take-back, a do-over, or a mulligan. This is precisely the type of fast and loose conduct that judicial estoppel seeks to quell. Get him! Alex literally wakes up and thinks, what lie should I tell today? I mean, that man is bored, okay? He's bored, sitting in prison. He ain't got nothing better to do except for bugging Jim and Harpootlian. But there is more. On May 11, 2022, Nautilus Insurance Company sued Murdaugh and others in the U.S. District Court seeking to recover the $3.8 million that it paid beneficiary to Corey Fleming. Again, Corey Fleming is I think they're like college buddies or something. College buddies, super close. Corey Fleming, also a lawyer, also in trouble, on behalf of the Satterfield estate, which was subsequently diverted. To be clear, the Satterfield family never received the first dollar of the Nautilus money. In its amended complaint, Nautilus alleged that Murdaugh filed a proposed confession of judgment on March 24, 2022, referencing the confession that is the subject of this motion. Amended complaint, page 18. On May 1st, 2023, Murdaugh filed his answer to the amended complaint, admitting the above allegation, thus stipulating the validity of the confession. Murdaugh did not take position that the confession was a nullity in the federal action. Just 15 days after stipulating the validity of the confession in federal court, Murdaugh filed the present motion seeking to invalidate the confession. Perhaps this filing will remind Murdaugh to amend his federal pleading to deny the validity of the confession if he at least wants to be consistent in his lies. When it served Murdaugh to parade the confession before the court as a sign of his magnanimous and contrition, he did so. Magnanimous is like someone who does like good. Contrition is like if you feel remorseful for something you do. When Nautilus said in effect, "Thanks for admitting you stole the money we paid to you beneficially for the Satterfield. We will like it back now." He reversed the course and now seeks to disavow the same confession. The goal of judicial estoppel is to prevent a party from playing fast and loose with the courts and to protect the essential integrity of the process. It must be weird to live in a world where the truth has absolutely no bearing on what you say or do. He's in custody now. The world seems to be getting larger these days. I bet he's already starting to scam other inmates, possibly. He's been doing like sports betting, in prison and stuff like that. I heard stories about him not being there, rushing back from work, but not possible for him to be there before EMS. That's what I was thinking too. I was like, how the heck would he have gotten there before EMS did, right? But yeah, I don't think he was ever there. Dingus, I'm so late. Hello, how are you doing today? Well, at least you made it. It's all good. Hi, Paul. How are you doing today? What's going on? Number 3, top. Did I read this part already? I did, right? Who has played faster and looser with the courts than Murdaugh? 3, top. The fact that Murdaugh's legal team had bigger fish to fry does not create a basis for relief. When the confession to judgment was agreed to, Mr. Murdaugh's counsel knew that he had stolen the money. They were unaware, however, of the details of the claim and underlying settlement, and in the run-up to Mr. Murdaugh's murder trial, they had no reason to delve into the issue. They had bigger fishes to fry. Simply put, wow, exclamation mark. In unpacking this one, it's probably best to create a timeline alternate to the one advanced by Team Murdaugh in order to dispel the notion that somehow Murdaugh's unwitting counsel got snuck up by those dastardly lawyers on the other side. As the timeline will show, not only is it untrue that Team Murdaugh had bigger fish to fry, Murdaugh had no other fish to fry. No fish sticks for you, Murdaugh. At the time of confession. All right, let's read the timeline real quick then. September 3rd, 2021. We're going to be in 2021. Murdaugh was forced to resign from his family law firm after his partner said he stole millions of dollars from the firm and the clients. The day after, Murdaugh called 911 to report that he'd been shot in the head while trying to change a tire. 2 weeks after, Murdaugh was sued by the Satterfield family for stealing settlement proceeds, and SLED announced it was opening an investigation. The day after, Murdaugh was arrested and charged with fraud and conspiracy in the fake roadside shooting scheme. He was quietly released on a personal recognizance bond and went to a drug detox center in Florida. A month after, Murdaugh was arrested at Florida Detox Center and charged with stealing millions from the Satterfield family. A couple days after, Murdaugh was denied bond by the Honorable Clifton Newman. Hey, Judge Newman! Note, negotiations for a settlement for the Satterfield civil's claim against Murdaugh began at around the same time. While the Satterfield had recovered in excess of $7.5 million from the other defendants, the suit continued against Murdaugh. December 7, 2021. Via email, Eric Bland and Jim Griffin negotiated the amount of the proposed confession. Eric Bland initially proposed $5 million. Wow. $5 million. Griffin responded with the proposed math, indicating an amount of 4.191 million, 4,191,200. To which Bland replied, Jim, symbolically, it's got to be four. Oh God, what are these numbers? 4,003,005. A copy of the email chain is attached in Exhibit E. Oh, I do have the email chain, but I don't think the email's spicy or anything like that. Not with Elaine and Sam. Hi, Misha. How are you doing today? How's it going? Thanks for popping on in. Hello. December 9, 2021. Ronnie Richter emailed Harpootlian and Griffin regarding the mechanics of having the Murdaugh confess his judgment to the Satterfields. Quotation marks. I just got off the phone with Amy Hill, the court-appointed receiver, who raised a very legitimate concern. Because Alex is locked down, he technically has no authority or ability to confess judgment. That is, unless the court grants him the right. In discussing it with Amy, it seems her best approach is to have the receiver petition Judge Hall for relief in the injunction to permit Alex to confess. The receiver supports the settlement we are proposing. To appease all other judgment creditors, the proposal would be to include language to the following effect. The receiver requests relief from the injunction to permit Mr. Murdaugh to execute the proposed confession while preserving for a later date arguments regarding the validity and or priority of other judgment creditors. A copy of the emails attached. December 9. In response to the email above, Harpootlian replied, fine with me. Emphasis added. Department. December 13. The Honorable Allison Lee set bond for Alex Murdaugh's financial indictments at $7 million. During the bond hearing, Dick Harpootlian told the court that Murdaugh agreed to pay the Satterfields $4.3 million. Yep, and he was lying through his damn teeth. Hi, Brandon. How are you doing today? How's it going? Did you have a good weekend? December 13. Following the bond hearing, Eric Bland emailed Amy Hill. Dick and I informed Judge Lee this morning that Alex would be giving and my clients would accept a $4.3 million confession of judgment in the pending civil suit. Are you drafting the motion on behalf of the receiver for the court to accept his agreement? Please let us know how John wants us to proceed. Once accepted, we have an agreement to have the resolution of the pending motions in the civil case. Thanks, Eric. Email attached. January 2nd, 2022. Eric Bland emailed Harpootlian and Griffin. Happy New Year. I got a call from Amy today who said that she needs either a covenant or a settlement agreement to submit to the court with a confession of judgment that we agreed upon. Dick, I recalled you were telling me that you were going to sign the confession of judgment and you would hold it in your file. Did Alex ever sign the confession of judgment? You've also said that you're going to make a few changes to the covenant. I've attached it again. Can you do it so we can get it over to Amy Hill this week for filing? There are motions scheduled in our case in a couple of weeks. I want to be able to let Judge Price know that we resolved everything. Thank you, Eric. February 9, 2022. In an email to Amy Hill and John Lay with copies to Harpootlian and Griffin, Eric Bland forwarded the proposed covenant and confession, but explained that the covenant was not final as Jim has to tweak it. Oh, excuse me. The email went on to make clear with regard to the confession, the Satterfields would become just one of the victim creditors who will have no priority over the other victims. A copy is attached. February 9. In an email thread between the attorneys and the Satterfield, Jim wrote at 3:21 with regard to the Murdaugh covenant and confession of judgment. Here are my tweaks in red line and clean versions. Ronnie Richter replied, wow, really quickly. Jim, I would only further tweak it to say that noting contained shall be construed as a waiver of Murdaugh's right to seek set off or credit. He can seek it. We don't stipulate that is entitled to it, but that's a fight for another day. The point was how to address the fact that the Satterfields had recovered against other parties in the event the receiver came into possession of funds, and Murdaugh wanted to advance the argument that in considering the Satterfields' right to further payment, Murdaugh should receive a credit or set off for other recoveries. Jim replied pretty quickly, here's the final agreed upon covenant. We agreed to the early confession of judgment document. Eric replied, also really quickly, Jim, first, thank you for getting the covenant today. Second, will you notify Judge Price that the hearings on February do not need to go forward, that they should be continued until Judge Hall either approves or denies the covenant or confession. March 1st to 7th, a lengthy email exchange occurring between the attorneys and Satterfield, Murdaugh, receivers. March 1st. Amy Hill wrote, please see the attached confession of judgment with Ronnie and any changes. We're working on the motion to the court and hoping to get that out tomorrow. We'll continue to the court and let them know it's coming. Hopefully, no need for hearing. March 1st, Eric Bland wrote, Jim, we have spent the last 3 negotiating this. Okay, Eric. March 7th, Jim Griffin wrote, Eric, I hate to upset the apple cart. That was an apple cart. But there needs to be a provision here qualifying that the allocation will be determined by the receivership court or other court of competent jurisdiction. Also, there should be a provision stating that by entering into this confession, the debtor is not consenting to the appointment of a receiver and does not waive his right to challenge the same. The conversation continued, and a complete copy of the email chain is linked here too. Exhibit K. The email chain culminates with Amy Hill asking Jim Griffin what was the reason for Alex to offer the confession of judgment. Jim Griffin responds, to end the litigation to avoid the unnecessary litigation expense to the Satterfields. Eric Bland emailed the Honorable Bentley Price, copying Harpoolian, Griffin, and the receiver, stating the part, my understanding is that the confession of judgment is going to be submitted tomorrow to Judge Hall for his approval and review. As such, if approved, all motions between the plaintiffs and Murdaughs will be reserved and dismissed. As such, we jointly ask that you once again continue the pending motion scheduled for March 16th until next month, your disposal, Judge Hall approved the order permitting Alex Murdaugh to enter the confession with the Satterfield. Wait, we jump like, what is a year later? Yeah, so we're in 2022 though. Sorry, guys. I missed that part. The approved $4.3 million confession was filed with the clerk's office May 31st, 2022. July 12, 2021. Wait, why are we back in 2021? Maybe this is a typo. Alex Murdaugh was disbarred after the South Carolina Supreme Court received a copy of the filed confession. July 14th. Alex Murdaugh is indicted on 2 counts of murder for the killing of his wife and son. Arguably, this is the earliest date when the run-up to the murder trials have begun. At this point, Murdaugh finally had bigger fishes to fry. Murdaugh pleaded not guilty to the murders of Paul and Maggie and requested a speedy trial. January 23rd, Murdaugh's murder trial began. March 2nd, Murdaugh was found guilty of killing his wife and son. May 16th, the present motion is filed. In essence, Murdaugh seems to contend that by claiming his legal counsel had bigger fish to fry, that he should be relieved from the judgment due to the errors of his legal counsel. Is he blaming his lawyers now? While styled as a motion of relief under Rule 60B3 or 60B4, this argument is more akin to relief under 60B1 as a result of mistakes, inadvertence, surprise, or excusable neglect. As such, the question posed is really twofold. Did Murdaugh's legal team make mistakes? And if so, does it entitle Murdaugh to relief from his judgment? Oh, man. He's throwing his lawyers under the bus. I mean, is that really anything new with Murdaugh? I don't know. As to the first part of the inquiry, it is difficult to say that a mistake was made in negotiation that spanned over 6 months with agreements that were materially negotiated. Happy money to you, too. And modified by Murdaugh's esteemed legal team, and which were ultimately presented to a court for approval with their consent. It is especially true in light of the fact that the false assertion of frying fish has been completely dispelled. An excellent discussion of whether attorney negligence entitles a party to relief from judgment under Rule 60 is found in the Ninth Circuit. The Ninth Circuit has repeatedly refused to provide relief on account of excusable neglect to attorney-based mistakes of law. Applying this principle, the courts have declined to vacate judgments under Rule 60B1 where the attorney committed an error of law. More citations. In short, Murdaugh's fish fry does not create a basis for relief from his judgment. Number 4, chunk. There is no technical defect in the confession that entitles Murdaugh to relief. Next on the T, Murdaugh contends that because of the technical defect in the confession that he and his legal team negotiated for over 6 months, asked the court to approve, and paraded before other courts in other settings beneficial to Murdaugh, he is now entitled to relief from his confession. I love the way how they word this. Man, I wish I was really good. I wish I was good at wording things like this. Before addressing the defects of which Murdaugh now complains, it is important first to look back to the genesis of the confession and its terms. Alex probably finds 700 years sentence too short. He wants more. He says, bring it on. As discussed above, the confession was the end product of months of negotiation between counsel for Murdaugh, counsel for Satterfield, and the court-appointed receivers. The receivership, however, was established in a separate action in the matter of Renee S. Beach as a personal representative of the state of Mallory Beach or Gregory M. Parker, the Beach case. Because Alex Murdaugh asked, I think Alex Murdaugh has appeared in court for the Beach case as well. Jesus, this guy is just he's just being dragged in all the cases, man. Because Alex Murdaugh's assets had come under the authority of the receivership in the Beach case, the parties in the Satterfield matter agreed to the receiver in the Beach case would need to ask the court's permission to allow Murdaugh to execute the confession. Permission in the Beach case was then requested by the parties in the Satterfield case. Murdaugh included. On May 16, 2022, the Honorable Daniel Dewitt Hall entered an order in the Beach case granting Murdaugh the permission to execute the confession that Murdaugh had requested to sign. So it looked like he went through a lot of hoops and hurdles just to get this confession of judgment in. A copy of the order is attached. With reference to the confession that Murdaugh was granted permission to sign, it contains a few important provisions that were conveniently omitted in the motion. Debtor admits liability to the judgment creditors for the claims asserted against him. Debtor hereby affirms and represents his judgment is legally binding and enforcing. He will not contest its validity or enforcement. Debtor has agreed to enter this judgment and any transfers contemplated herein or any transfers made pursuant to the judgment or intended by him to be a contemporaneous exchange for new value. Okay, so this is stuff that they omitted and they're just bolding it and making sure that's in this one. First, the confession itself bars Murdaugh's present motion does so by his own stipulation that he will not contest its validity or enforcement. Of course, the motion attempts to sidestep this bar by pointing vaguely to the same tired dialogue that Murdaugh's opiate use impeded his judgment. Oh no. He's saying it's a drug's fault now. Man, this guy just blaming everyone. Let's blame the lawyers. Let's blame the dogs. Let's blame the drugs. You know what? It's not the dogs. It was me who did it. Let's just blame everything. Let's blame the insurance companies. They shouldn't have been dumb enough to pay it off. Dude, Alex Murdaugh is he's wild. This guy needed to be locked up a long time ago before he even harmed his family. Yeah, no one caught him. I mean, they were slowly getting onto him, right? And then fucking Hail Mary decided to murder his family, probably to get sympathy and stuff. But yeah, that didn't work. Jesus. The drugs made me do it. But here again, by his own stipulation, Murdaugh agreed that he entered into the confession freely and voluntarily, that he would not contest in any way his capacity or authority to do so. Furthermore, with reference to the time provided above, Murdaugh was arrested in September 2021 and was released September 16, 2021. At which time he went directly to the drug detox center in Florida. He remained in detox until October 14, 2021, at which time he was remanded. I wonder when he was at the detox center, he was pretending to suffer from withdrawals. Jesus, I wish we can get reports on that. I know we can't, but because I remember how one of the brothers testified, I think. Then they said like when they were driving Murdaugh to like the drug detox center, like Murdaugh was like having withdrawals and he like literally like shat his pants. But I wonder if Murdaugh was just playing it up, you know, if he was really going through withdrawals or if he just really like, you know, I need to convince my brothers that I'm going through withdrawals and I didn't kill my family. So let me just shit my pants really quick to really convince them. Yeah. Dude, it's so dishonest that he probably even lies about the meal he wants when he orders at a restaurant. Remember he's saying that he was popping a hot... Oh my God, I forgot about that. Yes, dude, his lies were just so outlandish. Yeah, I was popping 50 to 80 pills a day. Uh-huh, yep, uh-huh. Yo, I completely forgot about that. In his remanded bond hearing in front of Judge Lee from Alvin S. Glenn Detention Center in 2021, 5 months before he gave the confessed judgment, Murdaugh told Judge Lee in a video that his head has never been clearer and that he is off drugs, is exercising, and is healthy. Those must have been some powerful drugs to have rendered Murdaugh incapacitated for the 10 months or so when he entered rehab and presumably stopped taking drugs. And at the time, he finally executed the confession on May 27, 2022. But we digress. Back to the technical defects. Wait, hold on a second. So Murdaugh is saying that his head wasn't clear at the time of the confession of judgment, even though apparently he was done with the detox center about like 8 months before. What was he doing? Getting drugs like in prison or something? Oh, God. Let's see. Okay, hold on. The motion cites South Carolina Code. Oh, actually, hold on a second. No, he wasn't in prison by that time because I don't think he was arrested until a year later, right? Yeah, he was not in prison. He was arrested way later. Okay, but he was in trouble for the Satterfield stuff. Okay. The motion cites South Carolina Code for the basis of asserting the alleged fatally defective flaws in the confession, which flaws render the confession void under Rule 60b-4. The logic here is muddled at best. Rule 60b-4 provides a court may relieve a party of his legal representation from the final judgment order proceeding if the judgment is void. The definition of void under the rule only encompasses judgments from courts which fail to provide proper due process or judgment from courts which lack subject matter jurisdiction or personal jurisdiction. There is no assertion of a lack of due process or a lack of jurisdiction here. In order to cure the obvious defect in this logic, Murdaugh pivots to argue, as best we can tell, that because of certain alleged defects, the parties, Murdaugh included, acted ultra vires. The fuck is that? Vires? Veers? What is a veer in law? The extent of a court or legislators jurisdiction to do something. Okay. Acted ultra vires. I don't understand how it works in the sentence, but okay. So to render the confession void. To condense the thought, Murdaugh contends that he asked the Judge Hall for permission to execute the confession, and when by order by Judge Hall said that Richard A. Murdaugh was permitted to sign the proposed confession of judgment attached to this order, there was a defect in the confession that was so pernicious as to nullify even Judge Hall's permission to sign it. As preposterous as that sounds, let's review the defects. Defect number 1. Here, the confession at issue states no facts whatsoever regarding the basis of Mr. Murdaugh's liability. To the contrary, the confession states that Murdaugh admits liability to the judgment creditors for the claims asserted against him in their complaint. This is known as incorporation by reference. The claims asserted Murdaugh in the complaint are factually rich and, more importantly, are admitted in toto through the confession. Into the confession? In toto? I don't know. Is toto a word? Murdaugh's motion mocks the very purpose of 1535-360, which is to protect against sham judgments that would only serve to frustrate or prejudice other legitimate creditors. Of course, this too is yet another flag that Murdaugh flies in his motion, waving his flag, that is really trying to champion the rights of other victims, the fallacy of which is discussed in the section to follow. Okay, tell us. Defect number 2. The confession must show the sum confessed does not exceed the liability. In the complaint that was incorporated admitted into the confession as being 100% accurate, the Satterfields describe in rich factual detail how Alex Murdaugh devised a scheme to use his position as a lawyer to steal 4.3 million. Sorry, I don't know why I read it like that. And to leave his clients who had just lost their mother with nothing, not one red dime. Yeah, it's so crazy to me that he didn't give them any money. Even, like, I don't know, like, give him like a couple $100,000. Be like, here you go. That's all I can get from them. Give him a couple $100,000. Like, he gave him nothing at all. The complaint included claims for breach of fiduciary duty and legal malpractice, and included a prayer for punitive damages. While Team Murdaugh has decided on their own after the Satterfield recovered in excess of $7.5 million, the Satterfield has been paid enough, which importantly was prior to the confession. Murdaugh stipulated in the confession to the liability for the claims asserted in the complaint that he was subject to a punitive award, and agreed by the language confession itself that it was given in exchange for release of further alleged liability. By settlement, Murdaugh received that value in the form of a receipt. Sorry, I'm pushing the statement. By settlement, Murdaugh received that value in the form of a release of the very same liability. There's no defect here. As for the idea of defects generally being a basis to set aside confessed judgments, our Supreme Court has not required strict statutory compliance in upholding judgments. As it relates to the statutory requirement of an affidavit or attestation of the debtor, our court held in, oh my God, sometimes these court documents are really tough for me to read. Okay, keep going. We're almost done. Here, the movement does not contend that there was a defect that somehow deprived the court of the subject matter jurisdiction to permit the confession. Moreover, to the extent that any defect exists, which is denied, it is a defect equally of Murdaugh's own creation. He is the rare litigant that would point to his own error as a basis to escape his admitted liability. This is Alex Murdaugh. Number 5, hook. Murdaugh's newfound concern for his other victims is not a basis for relief. First, it is the best of the product of very shaky memory to suggest the court of the confession works at a disadvantage to other victims, and it is worse, an outright misrepresentation to the court. As shown to the timeline and email communication above, it was discussed and agreed upon from the outset that if Murdaugh were to confess judgment, we would have to reserve for the later date arguments regarding the validity and or priority of the judgment creditors. This language carried through the negotiation and the execution of the judgment. The importance of this concession cannot be overstated. The Satterfields were the first financial victims of Alex Murdaugh to sue him. As such, they were first in line among financial victims, and they had continued their actions against him. They would have been first to obtain the judgment against him. As it relates to judgments, first time is first in right. The Satterfields agreed to give it priority and to join any future creditors or judgment holders on equal footing. Oh, that's nice of them. Not only did the Satterfields agree to this concession, they have lived up to it. On 3 separate occasions, the receiver has sought to sell a Murdaugh asset in order to create a pool of funds for the future distribution of creditors. So again, there's a lot of victims that Alex Murdaugh owes money to. And the Satterfields were the first to sue him. And what it's basically saying that, even though Satterfields were the first to sue him and probably the first to get all the money from him, they decide to be like, hey, you know what? We'll join in with the other victims and, you don't have to pay us first. We'll join with other victims. You guys can pay us all, maybe equally. On 3 separate occasions, the receivers reached out of the Satterfields through their counsel to obtain a partial release of judgment lien in order to allow the sales to take place. On 3 separate occasions, the Satterfields have executed the partial release to allow the sales of assets. Partial release of lien attached here to Exhibits N, O, P. Of course, these events were well known to Murdaugh at the time he filed for his motion, suggesting that if he didn't do something, the confession would only serve to harm his other victims. On the other hand, Murdaugh certainly knows how to work the system in order to give the judgment that creates the same inequity he suddenly seems duty-bound to prevent. On September 15, 2021, the Satterfield complaint was filed. October 28, 2021, Randolph Murdaugh IV sued his brother for $46,500. The very next day, Alex Murdaugh confessed judgment to his brother for $90,000, necessitating the receiver to file a motion. So this is Randy, right? Yeah, this is Randy right here. Oh my gosh, dude. Randy, you guys remember Randy at the trial? Randy was at the trial every day until I think they got to the finances part. And then I think at that point, Randy was like, you know what, fuck this. And I think Randy, when Alex Murdaugh was testifying, I think at that point, that's when he believed that Alex Murdaugh really did murder his wife and his kid. Just something about him being up on the stand, man. He just shady. Copies of the pleas were attached in Exhibit Q. On October 29, 2021, John E. Parker, former law partner and financier to Alex Murdaugh, sued Murdaugh for $477,000. On November 2nd, 2021, Alex Murdaugh confessed judgment to his friend, former partner in the same amount, necessitating another motion for emergency order, staying enforcement of confession of judgment. Copies of these pleadings are attached to Exhibit R. This is how you cheat in front of the line. This is how you use a confessed judgment to enhance the standing of another creditor over the rights of other. This is not what transpired in regard to the confession that is the subject of the motion. While not pretending to speak for all Alex Murdaugh victims, respectfully, we think you've done enough for your victims. Number 6, Duff. All right, almost done, guys. Almost done. Bubba, the true hero, true. Number 6, Duff. Pointing to other misconduct by the adverse party is not a basis for relief. Ooh, I'm getting hungry, guys. I'm gonna plow through this. In a confusing grant in a vacuum of legal authority, T. Murdaugh seems to contend here that he should be entitled to relief from his confession because Eric Bland called him bad names on social media, and or Nautilus should seek its money from the Satterfields and their legal counsel. The audacity. On November 22nd, 2021, T. Murdaugh filed an emergency motion for gag order and sanctions as to Eric Bland about his alleged extrajudicial statements to the press and to television interviews. Boo-hoo, Eric Bland is talking shit about you. As the parties negotiated to settle this case, it was known that the settlements would represent a complete release of all matters. The fact that all motions would be resolved by virtue of a settlement was discussed by and between counsel through the settlement discussions. Through the settlement agreement and the confession, the motion and other motions were made moot. Nevertheless, T. Murdaugh seeks now effectively to resurrect the very same matter that they agreed had been resolved in order to manufacture a non-existent basis to seek relief from the confession to do so purportedly because Mr. Bland and Team Satterfield had sought to harm other victims, and Murdaugh is now helping frame of mind. In truth, the motion really makes an argument that connects the dots between misconduct and relief, but instead, Team Murdaugh loosely cites other misconduct in an attempt to divert attention away from the indefensible behavior of their client and the nonsensical logic in their motion. To be clear, did we have a reply from the judge yet from this? This was filed when? June 6th? We have a reply yet? I know, right? What bad names. Yeah, Ray distanced himself from his brother after all was said and done. I am not my brother. I am a good lawyer. Yeah, I'm so glad. I hate it when family members just support each other no matter what, even though they know the family member's done fucked up. Listen, if your family member's fucked up, you don't need to support them. Loyalty, fuck that. Bye. You want to be loyal to good people. You don't want to be loyal to shitty people, okay? Without explaining how it creates any right to relief from the confession, Murdaugh's motion reaches its crescendo in suggesting somehow that Nautilus should seek relief from the Satterfields. Oh Oh God. Why? I don't understand. Why even suggest Nautilus to get relief from the Satterfields? Like what? Who thought that was a good move to even suggest that? Was Harpootlian and Griffin, were they like, hey, maybe it's not a good idea? And like Murdoch's like, no, let's do it. I'm the boss here. Let's just do it. I don't know whose idea was that. It just looks bad as well. While the Satterfield's legal counsel would recognize the sheer ridiculousness of such assertion, it is nonetheless upsetting to lay clients who have already been put through legal gristmill by Alex Murdaugh. It appears the Satterfield boys are not among the victims of whom Alex Murdaugh has a newfound sense of morality. Oh God, Alex Murdaugh and morality in the same sentence. Ugh. And given the role of Tony Satterfield in standing tall during Murdaugh's criminal trial, Murdaugh acts like one who has a favor to repay. According to the motion, the restatement expresses a common sense principle that if restitution for stolen money is given to the wrong party, the actual victim has a claim on that restitution, even if the source of the restitution is a third party paying on their behalf, because of the perceived joint liability with the thief. To which we reply, what? Gay? First, the restatement stands for no such contortions. Nautilus did not make a payment to Murdaugh by mistake. Again, they're saying that Nautilus didn't pay Murdaugh because they thought they believed his story with the dogs. They paid him because they didn't want to deal with his ass, okay? Nautilus paid money in trust to Corey Fleming to fund an agreed upon settlement for the beliefs of the Satterfield boys. Hold on. Nautilus paid money in trust to Corey Fleming, now the shady actor, to fund an agreement upon settlement for the benefit of the Satterfield boys. None of that money went to the Satterfield boys. In bold. When you're writing court stuff, are you allowed to write in all bold and capitalizations? Is that allowed? like this? I know you could probably do bold when you're doing like categories, right? But like just writing it like this. I don't know. Are you allowed to do this? I love it though. Okay. All of the money was stolen, misappropriated, etc. If the motion suggests that the money, i.e. the Nautilus money, should be traced and clawed back from the ultimate recipients, perhaps that is a legal support. There is a legal support for that proposition. Of course, the motion makes no accounting for those who actually received the stolen property and never suggests Team Murdaugh's own pockets should be examined for stolen money. Oh no, now the Satterfield lawyers are like, you know what? Maybe look into Murdaugh's lawyers. What's lining their pockets? What money is paying for their legal stuff? Is that what they're saying? Wouldn't that be a straighter path? To the contrary, in the game of legal bait and switch, the motion seems to want to put Nautilus hounds on the Satterfield trail, but that trail never crossed. On a completely separate front from the completely separate sources, sorry, my stomach is going to grow. The Satterfield family sued Murdaugh and others for their respective roles in the theft of their money. They made recoveries on theories ranging from malpractice to breach of fiduciary duty, negligence, and fraud. Back in quotation marks, back in bold. None of the money received by the Satterfield is Nautilus money, nor is Nautilus beneficially entitled to it. Thus, what the motion advances is a theory that Murdaugh and the beneficiaries of the stolen money should be able to retain that money because the Satterfields were successful in suing them and recovering from other sources. Not surprisingly, no case law is cited for this proposition. Also, not surprisingly, Nautilus have never made such a claim. Number 7, block. Murdaugh's spoliation of evidence makes it impossible to put the parties back to where they once were. By his motion, Murdaugh contends that he should be entitled to set aside his confession and restore the parties to where they were before the confession, in which case the Satterfield boys can just return to their lawsuit against him. While it has been deduced from that motion, it appears to be Team Murdaugh's theory that in returning to their lawsuit against Murdaugh, the Satterfields would have to prove that the dogs caused Gloria's fall, such that Murdaugh would have the liability for her injuries and death. Oh no, this is such a mess. Leave the Satterfields alone. Nothing could be further from the truth. Can't wait to hear from the judge. What the Satterfields would have to prove is that Murdaugh stole their money, a fact that he has admitted in the confession and under oath in the criminal trial. But clever Mr. Murdaugh would contend that there never should have been any money because Murdaugh obtained it through fraud. Thus, in Murdaugh logic, he could not have stolen that which he could not have possessed. Oh my God. This guy is I don't know, man. How is he so dumb but smart scammy at the same time? Jesus. So what is the real game here? If Murdaugh is right and he is most certainly wrong, then the Satterfields would have to prove the manner of Gloria's death, a matter which had been impossible by the fact that an unprecedented act of spoliation of evidence. Murdaugh has murdered only the surviving witnesses, true, who could have testified with regard to Gloria's fall. Based on the reports, the facts known to both Maggie and Paul at the time of Gloria's fall are preserved, but at the same time, they are precluded from use as hearsay. Thus, in asking for equitable relief from this court, Murdaugh's view of equity would be allow him to keep the stolen money, or at least not recover it from the folks he gave it to, relieve him from the confession that he executed voluntarily and freely, make the Satterfields return to the time and expense to their prior lawsuit, and in that lawsuit, tell the Satterfields that they have to prove how Gloria died, and do so without the benefit of the witnesses he has murdered. This is so twisted. This is like a fucking crazy, I don't know. It's like a crazy ass like true crime movie. This is so wild. So many twists and turns. We apologize for the length of that sentence, but it's reflective of the depths of the rabbit holes the team Murdaugh would urge upon this court. Murdaugh's spoliation of evidence is yet another reason not to indulge his ridiculous prayer for relief from the confession. Now we're going on to the motions of sanctions. God. Okay. At some point, some line somewhere has to be crossed by Murdaugh where the court will send a strong message to him and to his entire legal team to stop victimizing his victims, to stop weaponizing the legal system to extract punishment. Surely the legal Rubicon has been crossed by filing this motion, and anyone who facilitated its filing should be sanctioned. Get him! Get him! Rule, la 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 la. Under this rule, a party and or the party's attorney may be sanctioned for filing a frivolous pleading motion and or paper or making frivolous arguments. Elaine, where you at? I'm just kidding. I'm leaving Elaine alone. I'm sorry. The party and or the attorney may be sanctioned for filing a pleading motion and or paper in bad faith. The sanction may include an order to pay the reasonable costs and attorney's fees incurred. Man, I don't know if they're going to get any money from Murdaugh. I don't know, man. Yeah, I don't know. I don't know if they're going to be able to recover any costs from the Murdaugh people. Against frivolous actions, action brought in bad faith, reasonable fine to be paid to the court. Jesus. Skipping through a little bit. Skipping through frivolous civil proceedings, South Carolina. No reasonable attorney who spent 6 months negotiating the settlement of a case that involved a confession of judgment, who then petitioned a court to accept the settlement and to permit the execution of the confession, and then use the confession in other judicial proceedings, would wait another eve of the 1-year anniversary of the confession and point to phantom defects as a means to avoid it. Likewise, no reasonable attorney would misrepresent to a court that the reason the confession was executed in the first place was that they had bigger fishes to fry and were not paying close enough attention to detail, when the fish they were referencing, i.e. the murder indictments, did not exist at the time of the confession. Oh no, did they not have their timelines together when they put that in? Yikes. In the discharge of our Rule 11 obligation to consult, requests were made of Team Murdaugh to withdraw the present motion in order to avoid the time and expense of the reply. Those requests were unsuccessful, as shown through the attached email chain. I love when they found the receipt and got the testimony about the missing gun, and the spring man was shocked and pissed about that he ruined the story of the missing since Christmas too. Oh, so many lies. Oh, what was it again? The gun. You're talking about the friend that testified on the stand? I think there's 2 people that testified about the gun. One that was the person that stole the gun, right? I don't remember now. And then one was the friend that was really close with Paul, and then they shot together. How is Poon and Jim going to pay for their fish fry? Listen, I think Alex Murdaugh is just still pulling all the strings behind the scenes, and I think Jim and Harpoolian is just listening to under the direction of their client. I don't know. They probably oh God, we don't want to do this, but I guess, I don't know. Listen to the client. I don't know, man. The Satterfield boys have had enough of Alex Murdaugh. Their mother died at his home. From what is now known, it appears that by the time of their mother's funeral, Alex had already concocted a plan to monetize her death to his own benefit. Alex lied to them. Alex stole from them. Even now, as they try to put back the pieces of a once quiet, happy life, Alex Murdaugh is literally a hand from the grave, like a little zombie, that would not allow them peace. We pray to the court that a sanction will issue against Team Murdaugh that will finally shake his grip. Respectfully, anything short of sanction will serve to sanction his conduct. Signed, Bland Richter. We got Ronald Richter here, Eric Bland, and Scott Mongelo. I don't know how to pronounce that. Jesus. I don't know. I thought this was a really spicy read. A lot of stuff in there I didn't understand, but the stuff that I didn't understand, I was like, this is spicy. So I wanted to share this with you guys, and I wanted to read it with you guys. And yeah, that's where we're at with Alex Murdaugh. You know, we got a lot of crazy people that we're going to be dealing with for the next, next couple of months. We still got the Lori stuff happening. Have you guys heard any updates with Sarah? Actually, any updates with Sarah Boone? I know she got like pretrial stuff happening, maybe like a week before her actual trial, but I haven't heard any updates with Sarah Boone.